welcome to this week's edition of Wednesday Wisdom. My name is JB Hilliard, and these are weekly video snippets of information designed to answer questions you may have about estate planning or probate or other legal concerns that may be impacting your household. And for today's video, I thought I would talk a little bit about probate and the probate process, generally speaking, because I got excited. I'm such a nerd. I got excited when I received a mailing from one of the courts here for one of my clients that we've been waiting on for quite some time. And so I wanted to just talk briefly about the timing of the process when you are the person having to petition or probate a will for a loved one that has passed away, or you're the one that's left in charge of administering an estate if there is no will. Either way, there probably will be a probate process. If there's a will, definitely. And if there's not a will, it depends on your jurisdiction, but then it depends on what things need to be done for that person's estate. If there are claims out there that need to be settled, if there are accounts that need to be accessed, then you would need to petition the court to have the authority to do that as the administrator of the estate. So kind of with that in the background, you have to also understand that this is a process. Whenever you're dealing with the court, any court in any jurisdiction, the court has its processes. And then, at least here in Georgia, every county, even though there's a standard probate procedure statewide, but every county has its own processes and procedures that may be different from the next county. So you have to understand that this, whatever it is a process. And so I say all that to say, in this particular instance, I got excited because we actually started this process technically back in September of 2022 when the client came to me and we actually signed our engagement agreement. But the court process, once he signed the petition and got it, and we got it submitted to the court, that still took almost 6 months. And so you have to understand, the wheels that turn and how many different arms this thing can have. For one, you have to make sure you are filling out, drafting, and submitting the correct petition for whatever your situation is. Now, here in Georgia, we have a couple different petitions, well, a few different petitions if there is a will. We have a petition, a different petition if there isn't a will. We have a petition called No Administration Necessary. So there are different rules that apply based on the scenario of the person that passed away and his or her estate, excuse me, that will determine which specific petition package you need to prepare. Then there's the issue of making sure all the information is available to put into that particular petition package. I'm sorry, I didn't have my juice this morning. And so you have to make sure you're listing the proper information, that you're listing all of the heirs at law or the beneficiaries in the will, whatever applies, and understanding what heirs at law actually means. In your state, who's identified. If there's, let's say, father passed away and he has some children, and let's say 5 children, but 2 have passed away before him, now you have to determine, do they have heirs? Does your jurisdiction require that then the grandchildren are notified? And so all of these heirs and beneficiaries have to get a proper notice that this petition is being submitted to the court. So that's a process. That's a sub-process. And then once you get everything into the court, and the court reviews it and processes it and updates their database and does whatever they do with it, that's another process or sub-process. Then there's here in Georgia, we have a notice of publication. So there's a publication process that's a minimum of 4 weeks. So you have to have a lot of patience if you're on the end of being the one in charge now, either the administrator or the executor, or generally speaking, the personal representative of this individual's estate, having to wrangle all this in. Once it's submitted, you have to have patience that and let the court do whatever it is they need to do to ultimately issue you that court order that gives you the authority to act on behalf of that estate and take care of that estate's business. So it may not necessarily be 6 months or 8 months or 9 months in your case. It may be a much shorter time. But if there are other things involved, like multiple properties, heirs in different states, multiple levels of heirs, things of that nature, then it becomes a little more complicated, and then it becomes or could become a much longer process. So understand that patience is a virtue. As my mom used to always say, though, I stopped praying for patience, because when you pray for patience, God always puts you in situations that require more patience. So we kind of don't pray for more, but you do have to have patience, seriously speaking, when you're in the situation where you're dealing with the courts and their processes. So with that said, I thank you all, as always, for watching, and we'll see you next time.